Good morning. Welcome to the second day of the California Board of Accountancy. We are meeting at the Westin LAX, and it is May 19th, and I'm going to go ahead and call us back into open session, and we will start with a roll call. We'll start with Ms. Park.
Sunny Youngson Park.
Larry Kaplan.
Alicia Burhow.
Michael Savoy.
Mark Silverman.
Katrina Salazar.
George Familet.
Kathleen Wright.
Jose Campos.
Okay, and we are going to go ahead and start with our first petition hearing of the day. And we'd like to go ahead and have Mr. Gutentag come up, and we'll get moving.
Where should I sit?
Right there next to Mr. Sani. And I will turn it over to the judge.
Okay, good morning, everyone.
Morning.
Okay, are you ready to proceed with the hearing?
Yes.
Yes, Your Honor.
Okay, let's go on the record. Calling the matter of the petition for reduction of penalty by petitioner Mark Gutentag. This matter is before the California Board of Accountancy, Department of Consumer Affairs, State of California. Today is May 19th, 2017. It's a little after 9 a.m. We're in Los Angeles, California. My name is Eric Sawyer, Administrative Law Judge with the Office of Administrative Hearings. I'm sitting with a quorum of the California Board of Accountancy. At this time, I'll ask the parties to state their names for the record, beginning with the petitioner.
Mark Gutentag.
Good morning.
Morning.
Good morning, Deputy Attorney General Carl Sani, appearing on behalf of the people of the state of California pursuant to Business and Professions Code Section 5115.
Good morning. Okay, Mr. Sani, if you'd like to present the jurisdictional package and make a brief overview of the case, you may do so.
Yes, and I will be very brief, Your Honor. I would like to mark for identification and offer into evidence as Exhibit 1 the original petition packet with accompanying documents. The board members and petitioners have been provided with a copy of the same set of this exhibit. The exhibit totals 39 pages and is marked MG-PET 001 to 39, and I will be referring to the page numbers as PET followed by the page number. Your Honor, for the sake of brevity, I'm going to direct the board members to the summary of discipline and the history of this matter that's set forth on Mr. Franzella's memo to the board, specifically as described on page PET 002. The license history for Mr. Gutentag is found on pages PET 37 to 39 and reflect that Mr. Gutentag received his certificate number 27622 on March 30th, 1979, and the license has been renewed through 2018. In substance, the petition seeks a reduction of the remaining costs of enforcement costs that were charged to Mr. Gutentag pursuant to the prior disciplinary order, and he has an outstanding balance of $6,558 and has paid a total of $9,118. Thank you, Your Honor.
All right, thank you. Mr. Gutentag, any objection to this item being admitted and reviewed and considered by the board?
No.
All right, Exhibit 1 is admitted. I'm going to swear you in now, Mr. Gutentag, so please raise your right hand. Do you swear or affirm under penalty of perjury under the laws of the state of California that in this hearing you'll tell the truth, the whole truth, and nothing but the truth?
Yes.
All right. Would you state and spell your name for the record, please?
Mark Gutentag, MARK-GUTENTAG.
Okay, what would you like the board to know in addition to the materials and information stated in your petition?
Well, I think my petition is pretty clear, so without being repetitious, it's just, I've experienced extreme financial difficulty, which continues to this day. There's also a lot of personal problems in with my wife's health, and taking my focus away from just doing accounting. But it is all on my petition. I don't really have that much to add.
Okay, thank you. Mr. Sani, do you have any questions you'd like to ask Mr. Gutentag?
Just a very few. Mr. Gutentag, in addition to your statement in your petition at page PET 007 that you are in extreme financial difficulty, have you brought with you any documentation of your financial status, such as bank statements, a balance sheet, credit card statements, or the like?
No, I wasn't aware I should have, or, I mean, the worst thing is a foreclosure. I suppose I could have brought the foreclosure notice in, but that's really the worst thing that's going on.
Okay, the burden of proof is on you, Mr. Gutentag,
Right.
in this matter, so you have no obligation to answer this question, but are there any details that you would like to offer to the board members for their consideration in determining whether to reduce the, either completely or in part, the sums that you were ordered to pay pursuant to your disciplinary order? Let me back up.
Boy, you lost me on that.
That's what we call a lawyerly question. Let me see if I can be a little more brief. Is there any specifics that you would like to provide to the board about your financial condition that would help them make the determination whether to reduce the balance?
Beyond what was in the petition?
Correct.
Well, the only other thing, really, I mean, it's more of the same, I basically, keeping my head barely above water, and dealing with, I don't really have anything different than what I've said in my petition. I did end up in the hospital in February for about 10 days, first time in my life I've ever been in a hospital for myself, and I've been, working like a dog, trying to, just keep money, to stay ahead, but, it's very difficult. So that's where I'm at.
Okay. On page PET 19, there is a letter of reference from Mr. Bernard Golditch.
Yes.
Can you just describe your relationship with Mr. Golditch?
Yeah, I've known he goes by the name of Bud, and I've known Bud for, I guess, about 10 years. He lives about a half a mile from me. He has a CPA practice in Encino, and our wives were very friendly. Unfortunately, both of our wives suffer from chronic medical conditions also. And, I've known him, I've played golf with him, I've gone away with him, and he gave me per diem work. He stepped up when things were happening. He gave me some per diem work this tax season, and so that's my relationship. That's how I know him.
And he's aware of the disciplinary matter?
Yeah, totally.
You mentioned on page PET 6, in response to question number 4, that there is an unpaid judgment. Again, you're not obligated to, but would you care
Well,
to...
there were several lawsuits relating to the related matter, and one ended up where I made a financial arrangement, but I just couldn't do it, so there's just a judgment there. They haven't done anything to try to collect it, but, so I did, because I didn't comply with the...
I'm sorry, could you speak up,
Sure.
Mr. Gutentag? Repeat what you said and keep your voice up so everyone can hear. Maybe
Okay,
put
yes,
the
there
microphone
was-
in front of you.
There was one, of all the lawsuits, only one of them really ended up costing me money. I guess the good thing about not having anything is there's nothing for them to get. But I did make a deal on one that I couldn't fulfill, so that went to a judgment that's just there. They haven't tried to collect on it or anything, but it's just on, have a judgment for the damages that we agreed to.
Can you share what the balance is on that judgment? I take it's a public document?
I don't know. I think it's $40,000.
And you have not been able to pay that, correct?
No.
Okay. I have no further questions, Your Honor.
Okay, thank you. We'll open it up for board questions, and why don't we start this time to my far left and then come around if anyone has questions.
This is Jose Campos. There is a reference in the materials to the receipt of $750,000 to $900,000 of commissions related to the original. What happened to those funds then? So you're saying those funds have been depleted and there are no...
Well, between taxes and bills and savings, and my income dropped 80% overnight. So it was like, didn't take much to go through. So, and that was over a three-year period. It wasn't like I made $900,000 in 1 year. It was over a 3-year period. So between taxes, bills, I had savings, but I blew through the savings pretty quickly.
So those funds have been depleted?
Oh, yeah,
is the-
long time ago.
And then, second question, your statement on PET 007 indicates, with respect to the foreclosure proceedings you mentioned, you said I would most likely lose my home in October. Is that proceeding still in progress, or?
Well, it's confused. I mean, what happened was, this was originally a loan from my ex-partner. So it was a second on my house. I had borrowed some money a while ago, and then I couldn't make any payments, and he knew I couldn't make the payments, and, we haven't really said anything one way or the other to each other. He hasn't asked for the money, and I couldn't pay him. And I separated he was my partner that I separated from in 2009. And then I just get a notice that he sold a loan. It was obviously in default. And the guy called up and said, you're in foreclosure. We're going to put you in foreclosure. So that's how that came about. Not my first, it's a second.
And final question, other than repayment of the penalties associated with your probation, are you in compliance with all other aspects of the
Yes.
probation order?
Yes.
Okay. Thank you.
Me? Kathleen Wright. In light of the fact that we have not received documentation supporting your financial condition, could you give us an approximation of what the value of your assets are and then the value of your liabilities, so that we can make a determination as to whether or not you in fact are insolvent?
Okay. The only asset I really have is a house. It's probably worth $700,000, and it's got $700,000 of debt against it between the first and the second, and accrued interest and everything. I think there may even be a lien, the judgment, there may be a lien on there too. I don't have any other assets. I have no retirement plan. I've blown through that. I mean, other than, personal property and
Right.
those kinds of things. I don't have anything else.
Have you declared bankruptcy?
No.
Have you had debt forgiveness?
Yeah, a couple years ago, my first lender, I was able to get him to reduce the debt, get the company to reduce the debt.
Okay, thank you.
I have no questions.
Hi, Katrina Salazar. I noticed in your narrative explanation on page 9, it mentioned that you were behind, but that you were recently able to pay $1,000. Your amount paid that was noted by Mr. Sani of $9,118, does that include the recent payment as well?
I don't
Do you know if that's been applied?
I don't know.
I'm just trying to confirm the total payments.
I believe that would be correct, but I can't get verification. But that's the memo from Mr. Franzella is reflecting, we believe, total payments made.
So then, how about I ask a different question? When did you send in the last payment to the board, and then how did you send those funds? That might help add some clarity.
The last payment I sent was actually, I sent $250 a month ago. I think I sent $250 with the quarterly report that was due April 10th. So that was actually the last payment. I think that was the last payment I made. Now I'm not sure. Now, my memory's foggy on that now. I'm not sure. Maybe it was $1,000 I sent with that. I don't remember.
Okay. Thank you very much.
Mark Silverman here. Mr. Gutentag, can you give us some details on your present employment, whether it be contract work or otherwise?
For the most part, I still have my clients that came with me when I left the firm. I mean, lost a lot of clients that stayed with the firm, but the ones that came with me, I still have them. Very difficult for me to get new clients for the most part. When they Google it, all this stuff comes up, and You know, so it's difficult, but it's still tax and consulting, estate planning, real estate, you know, everything I've been doing for the last 30, 40 years, typical real, CPA practice.
Thank you.
I have no questions.
I have no questions.
No questions.
No questions.
Okay, why don't we wrap up, beginning with Mr. Sani. Do you have any final concluding comments?
Just very briefly again, we don't have a lot of specific detail, but as to Mr. Gutentag's financial condition. However, his testimony in and of itself is evidence. It's under oath. And we do have a significant payment history that has disposed of the majority of the amount that suggests that when he stopped paying the amounts due, that it was not due to capriciousness or a simple failure to make any attempt to pay the board those sums that are owing. So that's on the pro side.
Okay, thank you. Mr. Gutentag, you have the burden of proof, so I'll give you the final word. Do you have any concluding comments that you'd like to address to the board?
No, I'd just like to thank everybody for hearing my petition, and, you know, everybody's an accountant, so we kind of all know what it is.
All right, thank you very much. This matter is concluded and submitted for decision, and will go off the record. Thank you. The court reporter is going to give you a receipt for the transcript today, so just bear with us a moment or two. And let me check and see if Ms. Smith is here. Is Ms. Smith here?
Yes.
Would it be your preference to hear her?
Yes.
Okay.
Sure. We're going to take a couple-minute break, a couple of minutes.
Okay, are you both ready to proceed?
Yes.
Yes.
Okay. Madam Court Reporter, are you ready?
Yes, Judge.
Okay, let's go on the record. Calling the matter of the petition for termination of probation by Jessica Smith. This is before the California Board of Accountancy, Department of Consumer Affairs, State of California. Today is May 19th, 2017. It's 9:25 a.m. My name is Eric Sawyer, Administrative Law Judge with the Office of Administrative Hearings. I'm seated with the quorum of the California Board of Accountancy. This hearing is being conducted in Los Angeles, California. At this time, I would like the parties to introduce themselves for the record, and we'll begin with the petitioner.
Jessica Smith.
Okay, good morning.
Good morning.
Deputy Attorney General Carl Sani, appearing on behalf of the people of the state of California pursuant to Business and Professions Code Section 5115.
Okay, good morning. Mr. Sani, if you would like, could you please walk us through the jurisdictional documents, and if you'd like to provide an overview of the case, you may do so.
Certainly. I'd like to mark for identification and introduce as evidence Exhibit 1, which constitutes the petition and the associated documents. They are numbered JS-PET-001 to JS-PET-058, and I'll be referring to those by PET and the number when I reference specific pages. They include the petition for termination of probation, the original statement of issues case, a stipulated settlement, a decision in order dated or effective April 28th, 2013, by which Ms. Smith was placed on probation for a period of 5 years, and an order dismissing a petition to revoke probation. And the final document is the certification of licensure, which is found on PET 57 to 58, which reflects that Ms. Smith was granted her license number 118992 on May 14th, 2013, and it is renewed through July 31st, 2018, as indicated in paragraph 6 on PET 58. The petition raises really one issue, which is a petition to terminate probation. Ms. Smith has been on probation for a period of approximately 4 years, and her petition seeks to terminate probation about 1 year early. However, Ms. Smith has relocated to Texas with her newly married husband, and pursuant to the provisions of the stipulated settlement, her probation is tolled, that is, continues to run indefinitely while she is relocated out of state. And so I think that is the other material consideration in her petition to terminate this probation early.
Thank you. The petition and jurisdictional documents are marked as requested and admitted as Exhibit 1. Ms. Smith, I'm going to swear you in. Would you please raise your right hand? Do you swear or affirm under penalty of perjury under the laws of the state of California that in this hearing you'll tell the truth, the whole truth, and nothing but the truth?
I do.
And for the record, would you please state and spell your name?
Jessica Smith, Jessica, Smith, Smith.
Oh, I forgot to tell you before the hearing, but even though I'm presiding over the hearing, I'm not participating in the decision. It's the board that's deliberating and making the decision. So please feel free to address any comments to the board as opposed to me. The board has reviewed your petition and your attachments. Is there anything that's not in the petition that you would like the board to know about your situation or your petition?
Not at this time.
Okay, any comments you'd like to make to the board?
I'd just like to thank you for taking the time to hear my petition, and I'm here to answer questions if there are any.
Ms. Smith, if you could bring the microphone closer to
Oh, I'm
you,
sorry.
so that way we can hear you.
I
Thank
just
you.
said, I would like to thank you all for taking the time to hear my petition, and I'm just here to answer any questions should you have any.
Okay, thank you. Let's see, we'll start off, and Mr. Sani, do you have any questions for Ms. Smith?
Really just 2 questions, I believe. On PET 008, you indicate that you plan to stay in Texas for a while, with quotations on the "a while," and I wondered if you could inform the board as to what your intentions are as far as returning to California, or whether or not you have any foreseeable plans of coming back in the near future to California.
No foreseeable plans at this time, but I wouldn't rule it out. I never say never, so.
Ms. Smith, I'm so sorry. Could you
I'm
please
sorry.
talk in the microphone? Thank you.
No foreseeable plans to return to California at this time, but never say never because my family is here. So there's a chance I could come back at a later date, but at this point, I'm indefinitely staying in Austin, Texas.
Okay, and just to kind of synthesize your petition, the 2 grounds of your petition are, one, that you have been on probation for 4 years, is that correct?
That is correct.
And do you believe that you are compliant with all terms of probation at this time?
Yes, sir.
And the only other reason then is due to the fact that your probation is tolling, that is, it's now on an indefinite extension due to your non-residency in California, is that correct?
That is correct.
No further questions, Your Honor.
All right, thank you. We'll open up for board questions. Why don't we begin this time with Ms. Park?
I don't have any questions.
I have no questions.
Ms. Smith, Alicia Berhoff, excuse me. Do you practice in the state of Texas?
I do not.
So do you plan to get your license in the state of Texas?
At some point, I would consider doing that, yes.
Okay. Yeah, that's all the questions I have. Thank you.
Thank you.
Michael Savoy, what are your exact duties at the company you're working for?
I'm the Chief Financial Officer. So basically handling financial statements, banking, accounts payable, just the basic duties of a Chief Financial Officer. It's mostly a lot of accounts payable and just regular, financial reporting, cash flow for the CEO and president, things of that nature.
And you said this used to be a client of the firm you work for, where, in California?
Correct. The firm that I used to work for in California, this was a long-term client, and I actually worked on their account for approximately 8 years, and the business grew to the point where they were looking for a chief financial officer, and I was the natural fit.
And from California, you used to travel to Texas to work on this client?
Most of my work was done remotely, so I was I would say 99% of it was done remotely here in California.
And did they approach you for a job, or did you approach them for a job?
It was kind of mutual.
Thank you. No further questions?
No questions, Your Honor.
Hi, Katrina Salazar. Since you've last appeared in front of the Board of Accountancy, have you complied with all terms of probation as outlined in your agreements?
Yes, ma'am.
Thank you.
No questions.
Kathleen Wright, how long have you been in this tolling status? In other words, there's 5 years of probation, and if I'm correct, and I'm not sure I am, so this is my question, 4 years of the probation were completed, and then the remaining year, which is what you're asking for relief, is tolled because of your relocation. So how long have you been in this tolling status?
Since September 26th.
Okay, so quite a while. You were also asked to complete a rehabilitation program for first-time alcohol offenders, I think was
Yes, ma'am.
the reference. Did that help? I mean, could you tell us a little bit about your current status related to your issues involving abuse of alcohol?
I was going through a very difficult time in my life, and I have gotten my stuff together, for lack of a better term. I did go through the rehabilitation program. I have complied with my terms of probation as far as being subjected, for lack of a better term, to testing, meaning I have to check in every single day, no matter what day it is. And if I am selected for testing, I have to rearrange my schedule and go and do that, which is fine. It's part of my punishment for my crimes. I understand that. So I've really just, a lot of that has helped me kind of pull myself out of a dark place, I guess.
Okay, thank you.
No questions.
All right, thank you. Mr. Sani, any final concluding comments?
Ms. Smith has brought the appropriate vehicle for those rare cases of people who not just leave California, but actually relocate out of California. This is the mechanism by which the board can appropriately determine to terminate it so that it doesn't operate contrary to its original intentions. But for most cases, out-of-state tolling is appropriate. In this case, the board has before it a situation where the person is not intending to return to California for the foreseeable future, and that's the issue that the board will decide.
Thank you. Ms. Smith, do you have any final concluding comments you'd like to make for the board?
Again, I'd like to just thank you all for hearing my petition today, and I hope you can understand that this is just a chapter in my life I would like to close and move on with my new job, my new husband, and my new life. Thank you.
All right, thank you very much. The matter is submitted and the record is closed, and we'll go off the record. All right, the court reporter is going to give you a receipt for the transcript, and in a few minutes we'll hear from Mr. Baisden. So give us a few minutes to transition. Okay, let's go on the record. Okay, calling the matter for the petition for reinstatement of a revoked certificate filed by Lowell A. Baisden. This matter is pending before the California Board of Accountancy, Department of Consumer Affairs, State of California. Today is May 19th, 2017. It is 9:40 a.m. This hearing is happening in Los Angeles, California. My name is Eric Sawyer, Administrative Law Judge with the Office of Administrative Hearings, and I'm presiding over this hearing with a quorum of the California Board of Accountancy. At this time, I'll ask the parties to identify themselves for the record, beginning with the petitioner.
I am Lowell Baisden.
Good morning.
Good morning, sir.
Yes, Deputy Attorney General Carl Sani, appearing on behalf of the people of the state of California pursuant to Business and Professions Code Section 5115.
Okay, thank you. Mr. Sani, you can, if you would like, identify the petition, jurisdictional documents, and provide an overview of the case for the board.
Yes, Your Honor, I would like to mark as Exhibit 1 and introduce into evidence the petition and associated documents that are numbered as LAB-PET-001 to LAB-PET-110. Those documents include the current petition before the board, the underlying accusation from February 2007, the proposed decision and order revoking Mr. Basden's license dated November 26, 2007, a stay of execution of the decision, an order denying reconsideration, and as document number 6, starting on page 104, is the decision and order in Mr. Basden's prior petition for reinstatement that was dated December 31st, 2015, and became effective January 30th, 2016. And then the last document pertaining to Mr. Basden is his certification of license history, which is found on page 109-110. Mr. Basden was initially licensed with certificate number 26811 on December 1st, 1978, and was revoked as indicated in item number 5 on PET 109 in a decision that is dated February 7th, 2007. In the prior petition for reinstatement, the board made various findings, and those are found on 104 to 108. Your Honor, Mr. Basden has attached records to his petition explaining the grounds for his petition, which I think Mr. Basden is going to explain or characterize himself.
All right, thank you. The petition and those items are marked as requested as Exhibit 1 and admitted. Is there anything else at this time, Mr. Sani?
No, we can swear the witness, Your Honor.
Okay, Mr. Basden, I'm going to swear you in. Please raise your right hand. Do you swear or affirm under penalty of perjury under the laws of the state of California that in this hearing you'll tell the truth, the whole truth, and nothing but the truth?
I do.
And for the record, please state and spell your name.
Lowell A. Basden, it's Lowell. My middle initial is A. Basden, B as in boy, A-I-S-D-E-N. Basden.
Thank you. All right, is there anything in addition to the materials and information in the petition that you would like the board to know about your situation?
Yes, Your Honor. Yeah, I'd like to make a very brief overview, only because the tax return that is the subject matter of my revocation is actually a small part of a much larger thing that occurred. Basically, I had 7 clients who are using loan-out corporations. Loan-out corporations are a legal tax method. They've been around since the 1930s. If you don't know what they are, the individual contracts his services through the corporation. It facilitates the deducting of his business expenses. He can fund a pension plan, and it gives him liability protection. Those are the basic uses. Now, the IRS has long litigated against its use. In 1937, the IRS lost the seminal LOC case against Fontaine Fox, who was a well-known cartoonist. But nonetheless, that created the situation where today that the corporations are widely used in the entertainment industry, among professional athletes, and in the professions, including healthcare. And in my situation, that's what I had. I had 5 medical doctors and 2 medical technicians using these loan-out corporations. One of these technicians was Geilenkirchen, which is the subject matter of this revocation. In 2003, this goes way back, the IRS started auditing all of my clients. By 2006, they filed a lawsuit against me for promoting an abusive tax avoidance transaction, something we used to call a tax shelter. That came through in the 1998 Act. By 2007, They took me to the federal court in Fresno, and they, at the preliminary level, they sued me to bar me from preparing taxes. Well, they lost there at the preliminary level. In Exhibit 3, I provided 10 exhibits. I have what the judge ordered the DOJ to make a press release at that time. I'm just going to read one sentence from it. He said, the court did not find that Mr. Basin had engaged in or promoted a tax scheme, nor did it find Mr. Basin was engaged in a fraudulent tax promotion. The trial was set for June 2008. The problem was this. That all sounds really great. The problem was, it turned out I was the only person to ever beat the IRS on this issue at any level. They had prosecuted 200 such cases by 2007. They had started doing this in 2000. So the government's reaction was this. They stayed the 2008 case. I forget how they did that, but nonetheless, they criminalized me to influence the judge to bar me at the permanent level. So what they did in 2009 and 10, I was indicted 3 times. They indicted me on 3 of the medical doctor's returns. And by 2011, I pled guilty to aiding and abetting tax evasion on the 2003 tax return for one of those medical doctors. Now, I did that to avoid the 15 years the government was going to seek a trial, if you can believe that.
Mr.
So-
Baston, can I just point out, a lot of what you're saying is in the petition and materials that the board's read, and there's not as much point in just re-arguing what's already in the papers. The point today is
Okay.
to address any comments or questions the board has, or provide any new information that you would like the board to know. They've got your petition and they've read it.
Okay, well, I'll go to the next point I was going to make. Regarding restitution, I've provided those 2 new items of 2 documents which are new evidence since the last time I was here that I received in discovery. You saw the discovery response in Exhibit 7. You saw the documents in Exhibits 8 and 9. The Exhibit 8, it clearly shows that the Gottenkirkens voluntarily chose other people to do their work. It clearly shows that if you read the context of that last page, she actually describes the day when I was trying to secure that work from her to do the IRS appeal and to do her 2003 and 4 returns, and they wouldn't give that work to me. And I finally have evidence to show this board that that was the truth. Secondly, we have the IRS transcript right now that shows it was not a fraudulent tax return. There's no charge for fraud. So my point there, I guess the edification I want to make out of restitution is there was no restitution ordered here. The only issue here is any voluntary restitution. And I'm just saying no way can it be warranted. It's not justified in any way at this point. I mean, these people, it's obvious now that they came to this board and they lied to this board. I guess my edification, if I was on this board, I'd be very upset about that. That was a brief comment on restitution. A brief comment about cost of prosecution and investigation. Now, I feel pretty strongly about this, I got to tell you. And briefly, you saw in there that this board has the authority to eliminate the cost award. So, under BPC 5107D. I believe in the interest of justice that it needs to be eliminated. The edification I want to make from what I've already presented is that, and I didn't go into this enough depth in the petition. As you know, I presented there in Exhibits 4 and 6, I have the testimony of your investigator, and she had no tax background when she did this case, and she only worked for you for 2 months. My point is this, is that if you'd had the right person in there, I don't believe the accusation ever even would have been written, because these things would have been learned in 2006. The accusation occurred, it was dated, as you see, February 7th of 2007. And during 2006, you know, she would have got the tax account transcript, because when you do appeal work, when you get a client, the first thing you do is you get the transcript. You know, any tax person knows that. It's the official record of what's occurred on the return. You got to have it. And then if there's any work papers from the auditor appeal ongoing, you got to get all those. You know, people who do my kind of work, we get what's called the 9984 I talk about in there, which is the IRS auditor's time record. She would have been looking for that. Commonly, we give those to our clients to jar their memory so they can tell us about something about the case so we can help them. You know, if I was assigned to this, said, Lowell, go do this thing, I would have got the tax transcript, I would have got this, I'd be looking for the 9984 in the work papers, because commonly, by the way, it is my petition, the IRS auditors will share this with you. They'll give you the 9984 because they know that you can get it anyway. So she would have been looking for these things, and she would have discovered easily that 2 months before Jane Donnenkirchen even contacted you guys, she first contacted you in April 27th of 06. Less than 2 months prior to that, on March 8th of 06, she edified this 9984 for her attorneys and stated that she didn't want me to do the work. Your investigator would have easily seen that and would have questioned her on it. Said, what do you mean? You say right here that you won't let him do the work, and you're complaining that he didn't do the work? It doesn't make any sense. The other thing your investigator would have found is, even though the examination, the closure of the examination was not entered onto the IRS transcript until May 7th of 07, it was still more than 2 months away before the first hearing against me. But even more profound, in those days, it took maybe as much as 6 months to get the audit recorded on the transcript. So it would have been, they would have well known by the beginning of the year, January of 07, that, meaning your investigator, she'd been doing her job, she would have known that there was no fraud penalty. So it's not, by definition, it can't be a fraudulent return. So I doubt the accusation ever would have been prepared. So I'm just saying, I just think in this situation, the costs are not justified in any way. This never should have been prosecuted. Now, I can see this board coming back later when this got to a point later to where I got pled guilty to my criminal conviction, but that didn't happen in 2011. We're talking about this going on in 2006. This is 5 years later. It takes many years for the federal government to go through this process. So that was the edification I have regarding the cost of prosecution investigation. Independence. I didn't include this in the petition. This is one new item I wanted to talk about today. Because I realized later, I said, wait, there's also the cause of discipline regarding independence, that I didn't report my impairment in this compilation report. Well, very briefly, I would ask for the board for clarification, but I don't think it's possible, because the only comment the ALJ makes in his decision regarding independence is on page 11 in paragraph 27. I have that in here. No, I don't. I didn't do the petition. But if you looked at page 11, paragraph 27, he states that the corporation is my creature. A very odd comment. But the evidence of the trial showed that I didn't form the corporation. I didn't prepare any corporation documents. I solely advised the Donnenkirchens on their choice of entity, something that all of us do, every CPA does. Such advising is not an impairment of independence. If you look at the AICPA Code of Professional Conduct for 2007, in independence at 101.05, which is performance of non-attest services, which I provide as Exhibit H in administrative hearings, you will see that it's not listed as an impairment. This was always wrong. I would ask the board for clarification of where's my lack of independence, but I know that it's not there, and you could look for yourself. I brought a copy of that with me, but
All right, Mr. Baisden, let me just remind you, we're not here to relitigate the board's prior decision, and we're not going to, they're not going to entertain that. What they're going to do is make findings as to whether you're currently fit to have your license reinstated.
Okay.
My suggestion would be that you focus on that.
oh, that's next. Okay, my last point was there. I was going to ask them to eliminate it as a cause of discipline, but I'll move on. Regarding rehabilitation, you know, it takes up a large part of my 22-page petition because the factors provided in your handout to petitioners, which comes out of 16 CCR 99.1, if you look at that, there's 30 factors in there in 6 sections in order for this board to measure rehabilitation. You know, and I provide a response for all 30 of those in pages 12 through 22. I'm not going to go over those now, they're in there. But I did want to talk about that, Your Honor, very briefly regarding rehabilitation. I had some additional comments I want to make. I'm supposed to show this board, demonstrate to this board, to a reasonable certainty that I am qualified to safely engage in the practice of accountancy and that I'm rehabilitated. So in regard to rehabilitation, I want to, you know, now that I've completed my federal incarceration and probation period, which spans 73 months, I want to state that, you know, I earned 26 months of good behavior, 35% off my sentence. And these are the feds. This is a very difficult system. It's not like the state of California where you serve half your time and they let you out of jail or and things like that. I earned the maximum amount of good behavior. I did it in the months that you're first able to earn it. But my issue here is something not in my petition I've thought about later is this board doesn't think that's important. I know that because I read what was said in the last decision about it. But I want you to tell you it's a very significant thing. You know, I was in a prison with a federal prison camp, minimum security, with 100 white-collar guys like me, no problem with those people. You'd be fine with them. But there were 500 drug gang members in there. There were the Serenos, the Mexican gang from Southern California, MS-13 guys, Mexican Mafia. There were the black Crips in there. All the blue, they're both blue colors. That's why they're together. It was a horrible situation. These people are violent. They're only at a camp because of the time they got caught, they didn't have a gun and weren't doing something violent. But I learned by being there with them and by seeing their actions while I was there, they're extremely violent people. It was an unreasonable situation, I believe, for the federal government to put me into, but they did. And so, if one of you are like me, if you were in there for one night, that would be all you would need to be rehabilitated. You're done. You're not going to be doing whatever it is. But I was there for 861 nights. I was there for 123 full weeks. So it's a very significant thing. And I don't think it needs to be pushed off. I know it's not something ordered by this board, but it's rehabilitation. It was ordered by the federal government. It's significant. I also completed my probation. If you see the letter in Exhibit 2, they said I had a successful adjustment. You know, on your side, as you see, I did the 400 hours of continuing education. All the certificates are there. I don't need to go over that. But I did all the important and pertinent tax, accounting, and auditing classes. I like doing it. I'm all up to date. It's all a good thing. Went back and read more things. And then, but regarding this other issue, I have one other edification regarding, you have to determine that I can safely engage. And I do want to go to Exhibit 10, because I did say this in the petition. And it's very important, it's very profound. The senior judge in Fresno in the district court in 2014, when he did not bar me, from preparing taxes says this in his ruling. And it's very pertinent to what you guys are doing here, because you guys have brought up the same things he did. He said he looked at these things like the tax court saying I was ridiculous, and this board saying I'd likely transgress, and that I'd repeatedly prepared false returns, and that I continued to deny my own culpability. He mentions these on this page. But he says this profound thing for you to, I hope you guys can rely on. Well, the sentence is here. Can I just read the sentence, Your Honor, one sentence, or just edify the sentence? What's important about the sentence is, he said he's not convinced from the evidence that enjoining me from preparing tax returns for others is necessary to prevent interference with the proper administration of tax law. He's saying I can safely engage, that if I'm out there doing returns, I am not going to interfere with the proper administration of tax law. Another item not on my petition, these people looked at 53 tax returns because ultimately they audited 18 of my clients that involved 30 business entities and spanned 53 tax years. And the Fed spent a long time on this process. So he's looking at 53, whereas the ALJ here looked at one return. So I think it's very significant. I hope that you looked at the comments on page 20 that the judges made about me, because I don't have letter of recommendations, because I could bring them in here, people who know me, and write a bunch of flowery things that don't matter. But these judges are impartial. You know, they have the blindfold of justice on them. They don't care about me. And they said all these good things about me on pages 20 and 21. I hope you read them. Okay, I think that's more than enough on letter of recommendation. I'll conclude this way, with a strong point, and you may not like it, but I'm going to say it. You know, so it's okay to be wrong sometimes. I was on a public board in my hometown when I was younger. It was at that time a significant public board. We completed some projects that were really important to the community. But our staff would screw up, and we wouldn't know what they were doing. But when it came to, they'd be going way off the deep end and doing things that were bad. But once it got to me, I would get the board behind me, and we made it right. So I think this board is in the same situation. I've been there before in those public meetings with the people. You know, I think what happened here is wrong on this revocation, and I think this board needs to do what I've done in the past on my board to make this right, and the remedy is to reinstate my license. So thank you very much for listening. I appreciate it.
Thank you, Mr. Basin. Mr. Sani, do you have any questions that you'd like to ask?
I do. Mr. Basin indicates that he's seeking to remedy the decision to revoke his license. Mr. Basin, isn't it correct that following the revocation of your license, you brought a lawsuit to challenge the revocation of your license?
Well, I learned later when I got the new evidence, because I can't.
Yes or no?
Oh, okay, right now this is just a yes or no question.
Is it true I bought a, say it again, true that I bought a suit what?
To review the revocation of your license back in 2009 or 10, shortly thereafter?
Well, I brought a case to vacate it.
Okay, and after you lost that lawsuit, you appealed that to the Court of Appeals, correct?
No.
I'd like to show you, I think I've given you a copy of a 2011 decision, Mr. Basin against California.
Wait, that's on my original administrative license. Oh, you said the last time I was in here. You mean in 2015?
No, when you were revoked back in 2008,
okay.
you brought a lawsuit to challenge the revocation.
Oh, of course I
correct?
did.
Yes.
Yeah.
And after you lost that lawsuit, you appealed it to the Court of Appeals, correct?
Yes, I did.
Okay. I'd just like to introduce into the record, Your Honor, as Exhibit 2, a copy of the decision. Mr. Basin's been given a copy of it. The decision affirming the revocation of his original license is dated and filed January 6, 2011.
All right, this is a decision from his appeal of the board's decision?
Correct. To
With
the California Court of Appeals.
Okay, do you have enough copies for the
Yes.
board? All right, you have a copy of this, Mr. Baisden?
I do. Can I make one comment, Your Honor?
Hold on, I'll let you do that in a moment.
This would be marked as Exhibit 2.
So marked?
Mr. Basin, is that a copy of the Court of Appeals decision?
Yeah, it appears to be, yes.
Okay, I'd move to introduce that as Exhibit 2, Your Honor.
Okay, I'm going to ask you if you have any objections to this being admitted. You indicated before you wanted to make a comment about this, so this would be the time.
Okay, I have no objection to it being admitted, but I just want to comment that it's basically a rehash of the original decision. Excuse me. But obviously, since this is in 2011, this decision, they don't have the new information that you folks have regarding these two new items of evidence. If I had those at that time, I think there'd be a different answer, but I understand.
Okay, understood. I'll admit Exhibit 2. Go ahead, Mr. Sani.
Now, Mr. Baisden, you raised a lot of issues in your petition. I'm not going to go over them in detail, but is it true also that on November 2nd, 2016, you filed a lawsuit against Patty Bowers as the executive officer of the Board of Accountancy, Department of Consumer Affairs, Evan Gellenkirchen, Gellenkirchen, and Jane M. Gellenkirchen in the Fresno Federal Court as case number 1:16-CV-1651 AWISAB. Is that correct?
Yes.
Okay, I'm not going to introduce this exhibit, Your Honor, but I will seek to mark as Exhibit 3. That document, by the way, is a 131-page complaint. Don't want to go through it, but I do wish to introduce as Exhibit 3 the orders and judgment and findings disposing of this lawsuit.
Okay, Mr. Basin, do you have a copy of that document?
Well,
Okay.
is this mine?
Yes.
Okay, yes, I do.
Okay.
I gave it to
I'm
you
aware of
beforehand.
it, Your Honor.
Okay, it's being circulated to the board. Give me a moment.
I also have a comment.
Okay, all right, I'll get back to you in a moment on that.
Sure.
Do you have any questions for him, Mr. Sani, about this document?
Do you acknowledge that that's, do you agree that can be admitted?
Yeah, that's fine.
Okay,
Yeah.
you move to admit Exhibit 3, Your Honor.
Okay, Exhibit 3 is admitted.
And isn't it true, Mr. Baisden, that in this lawsuit, which was the final order on the last page is February 24th, 2017, the district judge affirmed a judgment against you in favor of the defendants, who I believe, Your Honor, to my knowledge, were never served in this case. That is, the court, if you read through the findings, I believe the findings reflect that the court sua sponte, that is, on its own motion, reviewed the complaint, found that this was the second complaint that Mr. Baisden had filed in Fresno Federal Court, determined that it was barred both by the statute of limitations, both under federal and state law, and also was barred by the doctrine of res judicata, which us lawyers say that having tried the lawsuit once, you can't file the same lawsuit again. And I believe that's, I just wish to make that as part of the record. So, Mr. Baisden, isn't it true that you've had an opportunity to raise your various claims, both when you challenged the original revocation of your license back in 2010, 2011, as well as in the federal court?
Well, there's a different statement of facts. The cases are not identical. There's different remedies as well, even though there is a common defendant, but it's a different case totally.
Okay, you didn't serve the federal
Well,
lawsuit, is that correct?
I have to get their approval to do that, and they never granted it. So,
Okay. So this was
right,
dismissed with a judgment against Mr. Baisden
right.
without him receiving approval to serve the Board of Accountancy. And for the record, Your Honor, I came across this in preparation for the hearing. This was not a lawsuit that the board defended because it was never served. But I believe for the record, it reflects that Mr. Baisden has had an opportunity to pursue these claims both in state and federal court, and those issues which he is raising have been rejected. Other than the comment by the judge that you referenced earlier, have you brought with you any other character reference letters that are anyway current?
Well, I said I didn't do that. I think what the judges said are more profound. Yeah. I mean, there's 3 judges in there you saw on page 20. There's, I don't like to say their names, but there's the judge, unless you want me to, Your Honor, enter them on the record.
It's okay.
There's the judge in the 2007 preliminary hearing. There's that judge who didn't find a scheme. There's a magistrate judge in 2013 who waded through the 53 returns, and what he said in his recommendation. And then there's the final one in 2014, which I have in here as Exhibit 10.
Okay, before I forget, Mr. Baisden, was there something that you wanted to
Yes.
say about Exhibit 3?
Yeah, I did. On this suit for monetary damages, which what I did was, just to make it real simple, is it turned out I wasn't even allowed to file that in federal court. In spite of the fact that they said it was res judicata, or I forget the other reason, whatever it is, it turned out it couldn't have gone forward anyway. I'm only allowed to file that type of suit in the California court. So, but anyway, since that time, just so the board knows this, because I've been up front on everything with this board, I have since filed that suit in the California system with the Kern County Superior Court. That suit is progressing, and of course, the state of California, and you have been served with it, by the way. I probably can remember the date. On just April 12th, last month, Patty Bowers was served with it. And then, but your attorney, Zachary Fancelo, who's a deputy AG in Los Angeles, he's already filed a demur on it, which is common. So, and that demur hearing is set for June 13. Yeah, June 13th. So, anyway, that's what's going on with that part of the case.
Okay, thank you.
Okay.
Any other questions, Mr. Sani?
No further questions, Your Honor.
Okay, we'll open things up for board questions. This time we'll start again on my left with Mr. Campos.
Do you accept any responsibility for any shortcomings in your professional conduct with respect to these prior matters?
Well, I think what I could have done differently, is what you're saying, is as far as my culpability in creating this situation, is, not that you using a loan-out corporation is that aggressive, but I was also putting those together with another legal tax method, which is real estate investment. And so all that winds up being very aggressive. You pay a low amount of tax, and it does attract audits. So I could say that to the Geilenkirchens, maybe I didn't make it clear enough to them. I thought I did, but I didn't by their reaction, that what you're doing here is aggressive. It's going to get audited. I did say those things to them, but it didn't land or whatever. I think other clients I've had who want to do that kind of work, they accept the risk, and it's okay with them. It's kind of like what Tim Cook at Apple said to the U.S. Senate.
May I interrupt you?
Yeah, go ahead.
I'm sorry.
No, go
I'm just
ahead,
going to
sir.
ask my question one more time. Do you
Okay.
accept any responsibility for shortcomings in your prior professional conduct that related to these matters? Yes or
Do I
no?
accept any shortcomings, is what you're
Any
saying?
responsibility for prior shortcomings in professional conduct that gave rise to these prior matters.
You know, I'd like to answer it this way if I can. I'm gonna, I know you want a yes or no answer. I understand that. In the federal court, here we go again. The federal judge tried to get me to do the same thing. And I said I would not admit to that. To get me to plead guilty, only thing he said was, do you agree to the plan? I said yes, because they wanted me to plead guilty, to say this. I wouldn't do it because I never advised them to deduct personal expenses. I never did that, yet they wanted me to admit that. I didn't do it.
Okay.
So you're going to say I have a shortcoming here. I think you'd have to be more specific, like they were. They'd say, will you admit this? They were very specific. I said, no, I can't admit that one. I didn't do that. You're saying shortcoming is just way too broad of a question.
Okay. I appreciate your response.
Okay.
Second question, what is your intention, or what do you intend to do if a CPA license is reinstated to you that you are not doing today?
Well, there's a lot I can't do today. I would do the same work I used to do. Right now, I'm just doing some consulting work. You know, I can't sign financial statements. And, you know, and given this situation, I'm not signing tax returns either. I'm just doing consulting work. So I'm a very long way from doing what I used to do, which for local business clients, you know, I did the ongoing financials and the tax returns and all the consulting that goes with that. And so, yeah, my hands are very much tied without having my license.
No further questions.
Okay. Kathleen Wright, what is your current status with the IRS? It appears as though you were assessed a practitioner penalty.
Well, you know,
yeah.
Yes. Well, regarding the practitioner penalty, they based upon the findings, they assessed $135,000 of penalties on the 6,700. And while I won't go through the machinations unless you want to know how they did that, but even though I was not barred from preparing, because there's more to it. But it's in what's called, as you all know, it's in NCN status, not currently collectible. So I just don't have any assets. I've met in Glendale, they have the large collection place there.
I guess my question is that when these types of issues come up against a practitioner under Circular 230, which is the regulatory guidance that governs practice before the IRS has the right to bar a practitioner from practicing before the IRS. That's their primary penalty. I know they have civil penalties and monetary penalties and so forth, but in this area, it's generally that they would bar you from practice before the IRS.
Well, I can sign I can sign federal returns right now. You know, a lot of that's changed recently as far as the definition of what practice is.
Yes, it has.
So practice is not preparing returns anymore. That's been clarified by the courts very clearly.
Well,
And-
okay.
No, it's been very clear recently, but I won't
Yeah,
go
I
over all
practice
that.
in this area, and yeah, fair enough. But the definition of, quote, practice and whether it includes
Well,
signing.
they
yeah.
just had the suit in Nevada a couple months ago.
I
you know?
understand that. Let me ask you a further question. Under what regulatory authority, though, are you signing returns? In the state of California?
I'm not signing any right now, but I could. I'm saying that I have a federal judge who didn't bar me from preparing returns.
That's fine. But under the law of the state of California, you have to be licensed in order to sign a return. You must either be a lawyer, you must be a CPA, an enrolled agent, or a licensed preparer.
Are you talking about being a C-Tech, you mean?
Yes.
Well, I haven't pursued that.
You have not pursued
No,
it.
because I'm not going to sign returns until I get this stuff resolved.
Okay. My second question then deals with the transcript that you gave us, the narrative, which explores in great depth and refutes the fact that the returns that were filed were fraudulent. And that came up a little bit in your testimony today, but my question is, and generally, just to explain to the other members of the board, the reason the IRS is reluctant to assess fraud penalties is because the burden of proof shifts. all of a sudden the burden of proof goes to the IRS to prove fraud, as opposed to being the burden of proof being on the taxpayer, which is typically the case. So generally, they are highly reluctant to assess fraud. And what they do is assess negligence penalties in the alternative, the most primary penalty being substantial understatement of the tax
Not
payment.
assessed, though, on this
Not, that was my
transcript.
question, was substantial understatement
No,
assessed in this
not any
case?
of the negligence or fraud, none of them. We're on, you can look at transcript yourself, they're not there.
Okay,
Yeah.
fair enough, thank you.
George Familette, having gone through all this, would you have gotten into the same type of business with these types of tax transactions if you had to do it over again?
I like this work. And like I was saying, it's, you know, it's tax mitigation work. You're complying with the law, but you're trying to reduce taxes greatly at the same time. I've had some tremendous success with this. But like I was saying to Mr. Campos, you know, it's kind of, I always like what Tim Cook said at the US Senate hearings, I think it was the Senate, where he said, Apple has paid all the tax it's required to. That was his answer. You know, which is true under law. They had done that until that gets changed. So some people may not like it, but you know, it's perfect. There are perfectly legal methods where you could reduce someone's tax to zero using the law. And you know, I like doing this kind of work. I'm actually very good at it, but maybe that's why the IRS wanted to take me out. So, yeah, so I put myself in a situation, I understand. But I would still do the work. I would still do this, what I've done. I wouldn't change. I'd probably be careful. I've always been very careful about the type of clients I took, though. And I never thought that I should have accepted the Geilenkirchens at the time. But another one of the medical doctors said, it'll be fine, and so I trusted them. Because the Geilenkirchens are very unsophisticated and not the kind of client I normally have, and look what happened. So I should have followed my instinct.
No further questions.
Okay.
No questions.
No questions, Your Honor.
No questions.
Alicia Verhow.
Yes.
So you said your current line of practice is consulting work. Why haven't you paid any of your prosecution costs toward the board?
Well, you know, I haven't had any money at all. I mean, even when I got out of prison in 2014, I had no work. The first time I ever had anyone pay me any money again was in 15. You know, when I went through this process, you know, my wife divorced me in that process. I mean, I lost all my assets.
Okay,
I mean, I really seriously had zero money.
got it.
So,
Thank
yeah.
you. If
My-
your license, I'm sorry?
well, aren't you going to ask me where I got, my mother actually gave me an allowance every week.
No,
so
I
I'd
wasn't
have
going to
some
ask
money.
you that.
Okay.
So no.
There you go.
If your license is reinstated, would you reimburse the board for the prosecution costs?
Well, you know what, I'd be able to do that because I'd be able to make some money.
Okay.
I mean, that would make a big difference, I would say. I still think they should be eliminated, but yes, it would make more sense in that situation.
Where do you currently reside?
I'm born and raised in Bakersfield. I've always lived there.
And you live there now?
Yes.
Okay. So when you, so you had a license in the state of Utah?
You know, I did only because I thought at one time, not that I was going to move there or anything, but there was a time in the 90s where Utah was claiming they had the most difficult standard to get a CPA license of all the 50 states. So I went to go get it. Because in the prior, it always had been California had been the hardest.
What kind of practice did you have in Utah?
I never did.
Oh, you never
I just
did. You
got
just
the
had a
license,
license.
just to
Okay.
so I could get it.
Okay. You haven't provided any letters of recommendation.
Right.
Or character references, so what can you show the board that you can be trusted if you have a reinstated license?
Only by what the senior judge said, where he said that I wouldn't interfere with the proper administration of tax law.
Okay. And then have you made any restitution to your clients from 2002?
You're talking the Geilenkirchens?
Yes.
Well, of course not. I mean, I haven't had any money to do it, but given this information, I know I have the proof now they lied on. But what restitution would you think I should pay them anyway? I mean,
My question is, have you made any restitution?
no, the
to your
judge ordered
clients?
none. I didn't pay any.
Okay, that's all I needed to know.
Okay,
Thank you.
I have no questions.
No questions.
Okay, thank you.
Okay, thank you. Final comments, Mr. Sani?
Yes, Your Honor. In reviewing the prior decision on the petition to revoke probation, I believe the concerns which gave rise to the denial of that petition remain present, frankly. And in addition, these other materials that have been disclosed indicate that Mr. Baisden has pursued all these legal remedies, has been unsuccessful in pursuing them because he does not accept responsibility for what he did. And he seems to indicate that if he were given his license, he would go about doing again what he did before, or something similar. So I believe that the evidence before the board does not show by clear and convincing evidence that Mr. Baisden has rehabilitated himself sufficient to have his license reinstated. In fact, there are indications in these documents that he would continue to pose a risk if he were reinstated to consumers in California. In light of the fact that there's no additional letters of recommendation or really other material other than these documents, we believe under 5115 the board should consider whether to delay the next reinstatement hearing for 3 years while Mr. Baisden takes stock of where we are and try to undertake some more serious rehabilitation efforts to ensure that if he were restored to practice, California consumers would be safe.
Thank you. All right, Mr. Baisden, you have the burden of proof, so I'll give you the final word.
Thank you. I understand how Mr. Soni can say that when a federal judge here, he's on page Exhibit 10 here, lines 14 to 17. A federal judge says that I can safely engage in the practice. He says this right here. It's not going to interfere. You're saying that I haven't taken responsibility. Well, I got to tell you, I'm glad I never took any responsibility in this 6700 case because the government didn't prevail against me. I knew I was right. I knew I had not done those things. Why should I admit to something I never did? And I won that on the civil side. I know there's a criminal conviction there, but only because the government used it as a tool to try to influence a judge at the permanent level. Also, it's just beyond me to know what kind of other if you want me to admit remorse or something, I looked in 99.1. It's not in there. It's not one of the 30 factors anyway to admit remorse or to say you're remorseful or something. I can see if I had stolen $1 million for someone, or if I was here because I had violently attacked someone, yeah, I would express a lot of remorse for those things. Those are very wrong. I would never do those things. But this is just not the case here. So I got to tell you, if this board decides not to reinstate me, please, please be very specific. Tell me what rehabilitation things I can do the next 3 years. I don't know what more I don't know what more I could do. I've done the community education. I did all the prison stuff. I have a judge who looked at 53 tax years and said, this guy can safely engage in the practice of accountancy. And I think that demonstrates to this board, I think I have met the requirements in 99.1, which is I've demonstrated that I am qualified to safely engage in the practice of accountancy, because this was always a federal matter, and the federal judge decided that at the end, that I can safely engage. It's very simple. Thank you, Your Honor.
Thank you, Mr. Baisden. All right, the matter is submitted, and we'll go off the record.
Okay.
All right, the court reporter will give you a receipt for your transcript. Okay, thank you.
At this time, we'll be going back into closed session to consider the cases Baisden, Smith, and Gutenberg. And at this moment, we are off the record. Okay, we are now back in session for the California Board of Accountancy meeting. We are now finished with our business of the day. Thank you very much for joining us, and we will see you again in July.